Attend the card, please. The Honorable Supreme Court of the State of New Mexico.
Afternoon, you may be seated. Thank you. Afternoon, we're here on S-1-SC-40715 Franklin versus Martinez. Petitioner, you may enter your appearance. Begin your presentation. You have 20 minutes.
Good afternoon, Kurt May on behalf of Brad. Our argument is very straightforward. Mexico's Constitution, Article 2, Section 4, grants every New Mexican the right to acquiring, possessing, and protecting property. And that right continues when a person becomes an inmate in Mexico's prisons. That doesn't mean that it's the same right or it's the same type of right that can be exercised outside the prison. There can be reasonable regulations imposed on that right, and they still have to comply with due process. And the reason that for this position that we're taking on this particular right here comes from various sources. One is the rules that the court uses to interpret constitutional provisions.
Can I interrupt?
Yes, Your Honor.
On the property right? When the Bureau of Prisons wrote the regulation allowing prisoners to buy canteen items from different canteens, different sellers, did they not, by adoption of that regulation, provide a property right?
That's exactly what we're saying, Your Honor.
Okay.
That's exactly what they did.
So as I understand the argument, that property right was deprived without due process of law.
That's correct.
So do we need Article 2, Section 4 to come to that, to do that analysis?
Not necessarily. I believe that there's two ways to look at it. And we lay this out in briefs. Is that first, you can look at the state constitution itself for that right. Our position is, why shouldn't corrections policies comport with the law? And we're saying here that the way it was written was an attempt to comply with the law. That it recognized that there's a constitutional right to acquire property that continues in prison.
I think we're talking about maybe a little bit different, is that when they adopted the regulation, they conferred a property right to purchase canteen items pursuant to that regulation.
Yes, Your Honor, that would be, that's why we talked about the Dilbray's case. That's a very similar question, right? Where the court looks to see what's the constitutionally protected interest at stake. And that's exactly what we're saying here too. But to go back to my other point is that when we look at section 4, and we look at the rules of interpretation, we presume that the people that wrote that know the meaning of those words, and that they use them in their plain and natural and usual way with the same significance and import that are common for those words. And when they wrote that particular provision, they did so with due regard.
So you're analyzing this just starting from looking at the New Mexico Constitution as opposed to first looking at the federal Constitution and how they've handled this?
Right, Your Honor. And our position, and perhaps this wasn't necessarily clear in our brief, but I want to make it clear. Our position is that this case is all about the state constitutional provisions, this court's interpretation of state constitutional law, as well as this court's or all the other courts' use of statutory and instructions, as well as instructions on how to interpret constitutional provisions.
So are you asserting that this isn't a Gomez case?
It's not a Gomez case, Your Honor.
Well, I'm going to press on that because I can see you making that argument when it comes to the first constitutional question. The first constitutional question is there a property right? But once we get into due process, which is a separate constitutional provision, you have conflict potentially between the federal constitution and the state constitution. Doesn't that pull this case into Gomez?
No.
And if, okay.
I'm sorry.
No, go ahead. Why not? Why not?
No, it does. First of all, because the right, you have to look at the right being protected, the right that we're asking to be protected in order to, that informs the due process analysis. And the right here is very specific and unique to New Mexico. It's a right to acquire, possess, and protect property. And so then you have to look at, okay, well, what's the process that's required in order to protect that? And the federal constitution does not have.
There's no analog. I agree.
Right. No analog and no analog at all. And there's been numerous instances, for example, in Van Solen, where the court just went straight to the Constitution and the protections afforded under the due process cases of this court. And that's the same thing that we're asking here. There's no overlap. The problem I think with saying that, oh, here's the state constitutional right, now let's look at the federal law on this, is that you're asking the federal law to interpret the nature and the scope of a right that's unique to the Mexican Constitution.
That's exactly what happens in the briefing from the state, from corrections, is that they say, well, first they boldly say that's Article 2, Section 4 is window dressing. Don't agree with that, and our case law says as much, that a property right is one of the most foundational rights in our Constitution.
Right.
But then they go on to say, and there's nothing to see here, see the federal constitutional analysis for due process.
Right.
What's your response to that? Is this, should we be looking at this through the lens of federal due process and Sandine or not?
No, Your Honor, because I'm glad you actually used that phrase, because that's the phrase that you used in Morris versus Brandenburg, that the due process right afforded to the person under the state constitution is looked at through the lens of the right that the person's seeking the protection for. And again, I go back to why are we looking at federal constitutional interpretation of the federal due process clause when we're talking exclusively about a state right?
But below, the court, the habeas court looked at both federal and state, and both were argued below. You've now winnowed Mr. Franklin's argument to the state constitution. But they did both, and now the state comes in pretty hot and says, oh, this is Gomez, this is Gomez, this is Gomez. And let's look at the federal constitution.
But if I go back to the court's opinion and Solon, the question that you posited there to start with the interstitial approach is this a right that's protected under the federal constitution? And you wrote, it's a simple yes or no answer. If the answer is no, we look at state law. And that's exactly what we're asking the court to do here.
And you would extend that to the due process arguments as well.
Absolutely. And I think the court has done that countless times. For example, in Miller versus Tafoya, that was again a prisoner rights issue where the court looked exclusively at its law, its due process law.
So let me ask you this, assuming that we believe that that Gomez does apply to question 2, whether there's a due process violation, what's your response to that? Assuming we disagree with you on that part, that second question, that we have to look at federal law under Gomez.
I'm sorry, Your Honor, but I have to stick with what I've said. I just don't see how federal due process law is any, I mean, it's anathema to what we're trying to do here. I mean, this court, one of the duties of this court is to interpret the state constitution. We're asking that you do that. We've cited a specific provision that covers exactly the facts that were developed here.
Mhm.
And we're asking the court to find that this is a right that's protected under the state constitution. And the process that's afforded that right has to be commensurate with the loss of the specific right that's in the Constitution. And that can only be done by looking at the state's own law on due process. It doesn't make any sense. I mean, if I were to go into front of a federal court and say, excuse me, I'd like you to analyze, Your Honor's, the scope and breadth of this particular state constitutional provision and how it should be protected under federal law. It just doesn't make any sense for me.
Can federal law become persuasive authority as opposed to binding authority?
Absolutely, Your Honor. I don't, so my practice has basically been all federal practice my whole career. And there used to be a time in the 10th Circuit that if you ever cited the 9th Circuit opinion, there were judges on that circuit who would scoff at you and say, we don't look at the 9th Circuit. That has changed in the meantime, but circuit courts do that as well. They look at other circuits too, and I know that this court has done that as well, looked at other decisions by other states and federal courts. It doesn't mean you can't look at them. What we're asking is what was said in Bright, that you don't have to necessarily follow it. Of course, being informed when the court's making a very serious decision like we're asking the court to make here, the court should look at various resources that are available to it, but it should not make the final decision based on what a federal court somewhere has decided.
With regard to the property right, what is your argument that acquire property is different? Do you agree that there's property right that exists in the federal constitution?
Yes, Your Honor, there is.
And you're arguing that somehow ours is different from the state constitution?
I believe it is.
And you can tell me what that is briefly, and then if you can share with me at the lower court, where did you make that argument?
Yes, Your Honor. So to answer the first question, how it's different than the federal constitution is the way it's written, which is again why I was emphasizing the construction rules for statutory provisions, is that you have to, we assume that what was written was intended. It was with the plain language to confer those particular rights to the citizens of New Mexico. That is not what's in the federal
Are
constitution.
you focusing on the word acquire or what do you?
I'm focusing
There
on,
it is.
I'm focusing on the phrase acquire, possess, and protect.
Do you know where acquire also exists in our federal history? Does it exist either in any pre-Reconstruction constitutions?
It may, I don't know the answer to that.
Let me, I don't mean to be tricky. Let me ask it directly. What specifically, because in preparation, there isn't much of a distinction between acquiring property and property. Some push it under like a liberty interest, but it is the concept that you have a right to property. I'm curious to know what acquire does that elevates that constitutional protection in New Mexico as compared to if it is something different. What does acquire do?
Well, to answer the very specific question about what the drafters intended acquire to mean in this context, I can only go back to what the construction rules say.
Okay.
That's it.
Okay.
But what I will say is that we cited Brooken, which is a case from 1914, where the court addressed this actual phrase, and the court said that is an enforceable right, and that the state cannot deny the right to acquire, possess, or protect property.
But Gomez came after Brooken.
I agree, Your Honor, but my point here is that in doing so, the court also said, because his attorney, Brooken's attorney, was arguing it's an absolute unqualified right, and the court said, no, it's not. It can be reasonably regulated for the welfare of the people. And
Like
that's
any other constitutional right. I mean, we have reasonable regulation on all manner of constitutional.
exactly. But that doesn't make it any less important or any less fundamental, or does it mean what it says it means by its plain language? That's the point that I'm getting to. I guess in the federal constitution, it shows up in Fifth Amendment and 14th Amendment as far as like a forfeiture of property without due process.
Mr. Meyer,
Yes, sir.
I'm sorry, did I interrupt you?
No, it's fine.
When I asked you earlier about whether or not the regulation creates a property right, I wasn't very clear. Under federal law, a property right is created when they adopted this regulation. The question, and where you're asking, I think if we can agree on that, then the question becomes whether or not the due process clause of the New Mexico Constitution provides greater protection than the federal constitutional, in that the property deprivation imposed and the atypical and significant hardship in relation to the extraordinary incidents of prison life. That's the Sandlin test, federal. And you're saying, as I understand it, that the New Mexico due process shouldn't be that stringent.
That's exactly what I'm saying.
So, but can we agree that you have a property right under the federal constitution as it is, as well as the state constitution?
I would like to distinguish what Your Honor just talked about. The federal courts talk about in prison context, which is where we are here, about the possession of property. And that is a right that is, once the prisoner affords that right to possess personal property, that's a right that can be enforced. But I do not think that Sandlin has any control here. And I'm going to get into the weeds here for just a moment. Sandlin was used by the 10th Circuit in Costco versus Huff. And Costco versus Huff dismissed the same type of analysis that this court used in Udobre to come to explain how a right is derived, how a constitutionally protected right is derived by a regulation. And that's why I think Sandlin has no purpose here and no relevance. It is because the court's already in conflict with circuits or the Supreme Court of the United States.
Going to the senior justice's question though, and potentially the chief's question, I want to try and understand. I think what they're saying is possibly that the right to possess property and the right to acquire property are basically the same thing because you have to acquire property to possess it.
Right.
And so to the senior justice's point, he's saying, well, there's a property right, no matter which constitution you're looking at. And where the rubber meets the road is in what lens do we view due process?
Right. I don't disagree with that, Your Honor.
If that's what they're thinking, I'm putting words in their mouth.
I don't disagree with that, but here's where I go back to, I don't mean to be difficult. It's just that I believe that this is the factual circumstances here are a little bit different because everything about this case is about the right to acquire. You never got to possess. And the reason I analogize it to an Albright is because, again, you have these substantive predicates and the Albright was a liberty, here's a property of trust, right? Where you have things where a person, and we're not saying that he has right to acquire, that the policy gives him, or like a remedy is not, you have to let him purchase these items.
It's not an unfettered right.
Right, exactly. There's discretion there, but
But
he,
discretion is related to things like contraband and
right,
not coffee.
right, and the policy itself has two phrases in there that says the property officer shall make a recommendation about the proposed acquisition and shall ensure that the proposed acquisition complies with policies and procedures.
Not too many magazines, not too many street clothes.
Right. And so again, in and of itself, it provides, there are restrictions on discretion. It's not unfettered. It's not,
Here it's that they offered for vendors and then pulled the rug out from underneath him by saying, nope, it's just the one. And gosh, it just happens to be the one that's infinitely more expensive and is paying a lot of money to corrections to do it.
right. And if you go then to the Eldridge factors and look here, is this the process that this right under the section 4 is entitled to? And it's not, right? Because it's
You
very,
have Udebray. I don't know why you're going down this road then. It's not now it's Udebray, it's Udebray. So I'm wondering why you're asking for this additional right in the acquiring of property. Did you argue Udebray below?
I argued Udebray in my briefs, but it wasn't
Where?
argued. It's in my opening brief and the reply brief.
Here?
Yes, Your Honor.
Did you argue it below?
No, because it wasn't out yet. The court hadn't published it.
Did you argue the concept outlined in Udebray below?
That was not necessarily argued, the concept. But as far as the preservation issue, and again, this is where I would go back to just Gomez for the preservation rules, not because it applies here, but simply that you have to raise the constitutional provision under which you're seeking protection, which was done here. And I would say too, Your Honor, that, and I laid this out in our reply brief, we explained how the council there did cite to section 2 and subsection 4 and 18 and explained how they applied and how the due process, what type of due process is due there. So, thank you.
10 minutes on the bottle. From the state.
Good afternoon. My name is Kelly Garcia, and with me at council table is Meryl Swanson, and I represent the respondents. Petitioner is incarcerated at the Southern New Mexico Correctional Facility, and he asks this court to find that the conditions of his confinement are unconstitutional because he was told he could not order a list of 15 items from Walken Horse, which is under New Mexico Corrections Department policy, an approved vendor. He also was told that 4 of the items on that list, specifically a typewriter, beard trimmers, tablet, and a game console, he would not be allowed to order also because they were not part of the personal property index that is also contained in corrections.
But coffee is not on that list, right? I mean, there a lot is made of the things that were expressly denied because they weren't on the list, as opposed to focusing on here, that Walking Horse was an approved vendor at the time of the request, and then, oh, they're not an approved vendor now. That seems to me the more cogent problem here.
Certainly. And he was told that, as the record shows, that the directive coming from corrections overall, I believe the record says that it's, they're only to order from Union Supply. I don't know why they were told that Union Supply is the only one to order from, and that did not come out below.
Well, there's a reasonable inference, right? Because there was quite a bit of profit that DOC was getting as from Union.
Certainly that inference could be made. However,
But it actually frankly doesn't matter why, because corrections had published an approved list of 4. And then without telling anybody said, oh, never mind, it's now 1. That's the problem. I don't care as to why, because that's not our, so you don't have a hat to hang, a hook to hang your hat on there either. Certainly not because the others were nothing but contraband or they were committing fraud or something like that. We just know, or were approved. You've ordered from an approved list and was told no, without tying it to one of the fundamental reasons for curtailment of a property interest. Why isn't that a problem?
well, what it comes down to is, and this is what my understanding the appeal is of the district court's holding, whether the corrections department policies create a protected property interest.
Under Udebray, is it not a fact that the regulation saying there's 4 approved vendors that created a property right in the prison population?
Well,
Very simple question.
I would argue that it's slightly different because Udebray looked at whether substantive predicates were met. And in Udebray,
But it outright said they had a property right in earning those credits.
yes, there was a liberty interest in the eligibility to receive those credits for completing that program.
In this case, saying you've got 4 approved vendors creates a property right in, or if you want to call it a liberty interest, in purchasing from those 4 vendors.
The other consideration that comes up here, Your Honor, is that as it's been discussed in our case law and also in federal case law, that a prisoner's rights may be curtailed when they enter the prisoner's door.
But that wasn't my question. My question was, under Udebray, issued the regulation, this created a right in the prison population to purchase from those 4 vendors.
The state does
Whether
not,
it's state law or federal.
I respectfully disagree with Your Honor.
Okay, what authority do you have?
Under Cordova v. Lee Master, this court interpreted and took into consideration Sandin v. Connor, which is the U.S. Supreme Court decision that said that every little policy inside corrections will not create a protected property or liberty interest.
Let me ask you a question about Udebray.
And then I'm gonna come back to Chad.
Sure. In Udebray, the policy was based on a statute. Does that make any difference here or there?
It may, Your Honor. I think perhaps it's a bit stronger coming from a statute, and because here we're talking about a prison policy, and we do have language from Sandin v. Connor adopted by Cordova v. Lee Master, which says that prison policies won't necessarily make or create a protected liberty or property interest. They create that protected interest when they do something creates an atypical and significant hardship in the everyday incidences of prison life.
So I knew you were gonna hang your hat on Cordova. So let's read what Justice Zinsner said in Cordova. In making his constitutional claim, petitioner cites Articles Sections 13 and 18 of the New Mexico Constitution, which are our state counterparts to the 8th and 14th Amendments of the United States Constitution. He does not argue, however, that we should interpret our state constitution to provide petitioner greater protection than he is afforded by the federal constitution, and has not articulated a basis for construing the state constitutional provisions more broadly than the federal. So what Justice Zinsner says is, you didn't bring me the arguments, we're stuck with the federal interpretation in Sandlin. Cordova does not adopt Sandlin as the test in New Mexico for deprivation of a property right under the New Mexico Constitution or New Mexico law. It is very limited in its nature. So that's why I brought it with me. I think, Minsner is complaining there, as we do in opinions over and over and over again in this court. You didn't bring me the argument, we're stuck with the federal interpretation. Here, the argument has been brought to us. So Sandlin, I don't think is controlling. Also, Sandlin talks about liberty interest, not property interest. And I think that's an interesting distinguishing factor as well. And feel free to respond to any and all of that.
Well, Your Honor, is there anything in particular you'd like me to address with that?
The answer brief goes in, it leans in significantly to cases including Sandlin that focus on liberty interests.
Right.
And pretty sure every case cited in the answer brief focuses on liberty interests, not cases talking about property interests. So what's the bridge there? Given that we've said some fairly strong things in our jurisprudence about New Mexico's constitution, right?
Okay, there are a few things I'd like to address. I hope I can get through them all. So one thing that I think, and I hope this will address some of the concerns here, is that in Cordova, Justice Minzer, as Your Honor pointed out, also asked whether there was a limitation to official discretion in the prison regulations. And my understanding is that Mr. Mayor or Mr. Franklin have also sort of invoked that, the limitations to official discretion, and sort of whether or not substantive predicates are met. The state contends that the prison policy does not create a property interest, in part if we're going down that substantive predicate line, because there are various places in the Corrections Department policy where a large amount of discretion is built in to prison officials overseeing these purchases. Indeed,
But it's tethered to lots, to that point, isn't it tethered to lots of explicit language though? Like I wanted to print it out and look to see if there was more than kind of what I assumed there might be. And the discretion or the curtailment, the way that corrections describes the curtailment of the property interest is pretty explicit. You can only have X number of magazines, it can't be pornography, you can only have 5 kind of streetwear shirts if you're doing work release, it can't be contraband. And so they expressly lay out what the contours of the restrictions are, the curtailment is. That's what guides our view. And if you look at Udobre, that's what we engaged in as well. So I don't think it leaves discretion that is unexpressed available to the Corrections Department, because otherwise there would never be due process for a prisoner in any context if the warden could have secret curtailment. It has to be an express curtailment. That's what due process requires. So if I'm right about that, there's lots of areas in here where it can be curtailed. How does that curtailment preclude Mr. Franklin from buying coffee from an approved vendor? And I focus on coffee specifically because it seems to be the least, kind of salacious is probably too big a word, but one of his requests was coffee.
Sure, and as Your Honor pointed out, the why doesn't matter. And in fact, we don't know the why. As to other places in the policy, though, where the right may be curtailed, as was pointed out in the petitioner's brief, the property officer, and I apologize if I'm getting that term wrong, but the property officer makes the recommendation in effect to allow or disallow the purchase order after the inmate makes it. And that can be based on whether the item may or may not be contraband.
But we define contraband.
But the contraband isn't a fixed definition.
It wasn't denied because it was contraband, because they said you can get it from Union Supply. all about the vendor.
Right, and I guess I'm getting back to the amount of discretion in the policy and whether or not a corrections official could deny it, because it goes toward whether there is enough discretion in the policy such that a protected interest is not created by it.
This is a very similar conversation that we had in the, so, maybe elevating a little bit will help. Let's start at the top. You agree, federal constitution gives citizens property rights.
Yes,
Agree with that, and can dispute whether, assume for purposes of this question, acquire property equals property under the state constitution. When you go in and you're incarcerated, you can limit those rights, correct?
correct.
Now, you limit it based on, and the discretion is limiting it and imposing these regulations. The regulations at issue here, correct?
Yes,
And they wrote very specific regulations on how to buy things. This goes to senior justice's point. You've told them, this is how you may, we're going to limit your property right. This is how you do it. And the decision that the inmate in this case bought it based on what your regulation was. And you said no. And that's where my due process concern comes in, because there is no explanation at that point. I don't think, at least I am not asserting, Department of Corrections cannot have limitations on the procurement for contraband or other reasons, but it's very similar to, right? Once you said you can do it like this and this and this, that then invokes the right of that prisoner to buy it that way. And when you take it arbitrarily, it violates Sudabre. Why, where in that thread do I go wrong? Is it, you're just saying they have additional discretion on top of who the vendors are?
in my mind,
Yeah.
sorry. In my mind, the way it breaks down is that in, I say Huidobre, I'm probably saying that wrong, I'm sorry.
Me too.
In Huidobre, an inmate completes a program. After completing that program, the inmate has an expectation that they're going to be eligible for the lump sum award of good time. I believe under the Corrections Department property policy, after the inmate completes that purchase order, they don't have necessarily the same level of confidence, or they shouldn't have the same level of confidence that the purchase order will be approved and that they will in fact be able to acquire the item. Because the item can be, it could be deemed contraband.
That didn't happen.
Right, it did not happen here, but we're looking at whether or not there's a property right. So it's this more esoteric look at the policy.
I disagree, because the way that corrections, again, I've said it 3 times, the way corrections can curtail the property right is to expressly state, these are the things that are out of bounds. And if it's not out of bounds, otherwise you can shop with these 4, I know they call them canteen, but like 4 catalogs. You can shop in these 4 catalogs. Granted, there are some things in those catalogs that are still out of bounds because you can only have a certain number of things. But once they say, if you have the money and you follow our process, which is to order from these 4 vendors, subject to the other rules in the policy, it's not any different than Huidobre, that the precursor, the qualification that you talk about in Huidobre is present here in the same way. It's just different facts.
I can see the court's point there. However, what can be considered contraband is a more fluid and evolving concept. I don't think that it would be possible for corrections to have a policy that had a finite list of things that can be considered
Where in the
contraband.
record does it show that it was denied because it's contraband? It was denied because of the vendor.
It was denied because of the vendor. However, to the extent the court finds and I'm not agreeing with this, but I'm just saying for the sake of argument, if there is a due process right here and there is a violation, I'm sorry, there is an alleged violation of due process and there is a property interest, then what would need to happen is then the Matthews v. Eldridge analysis, which would then require the balancing of interests, one of which is the state's interests. And that, at that point, is when it may matter why corrections decided to just go with union.
But the argument is that that does not comport with New Mexico due process under Article 2, Section 18. That's the argument. The argument is we don't follow that. We have our own due process.
Right.
And did not comply. That's the argument. So, if obviously, if it complied with, if it did not comply with federal due process, we wouldn't be here.
Let me see if I can find something helpful or useful to respond to that.
The argument is that New Mexico due process is different than the federal due process.
Doesn't that mean something?
Yes, it does. However, under either, including the New Mexico due process analysis, there still has to be a protected interest.
Assume with us, we think there's a protected interest. I want to get past that because, again, the crux here, I think, to my mind, is what due process are we applying? Federal due process or state due process? And I don't think, whether you say the policy creates the right or the Constitution creates the right. It's been talking about what process is due.
And I think based on the clarification that my opposing counsel gave in his argument, and also the clarification that came out of the reply brief, it appears that we'd be looking at state due process because this is not a Gomez issue. It's not a Gomez preservation issue. So we're looking at the claim under state law and the limitations of New Mexico's constitutional protections.
So is that just a Huidobre analysis?
It seems like Huidobre is probably the most straightforward guiding principle here. However, I understand Justice Bacon's concern with looking at Cordova v. Leemaster, but the guidance there is also relevant, that the Corrections Department has a legitimate penological interest in overseeing and maintaining security of its institutions, and that extends to limiting what items come into a prison. And the items that come into the prison are going to be largely determined by this policy.
There was some language in Sandlin that I thought was really interesting in one of the dissents. Justice Byers engaged in a discussion where he said, this court has never held that a comparatively important prisoner deprivation fall within the scope of the due process clause, even if a local law limits the authority of a prison administrator to impose such deprivations. And in my view, it should now simply specify that they do not. And then he goes on to talk about the courts having to determine whether there's an important, a big interested issue or a little interested issue, and what the differences in the due process that would be applied in those circumstances. And he talks about the examples he gives are less significant matters such as television privileges, a sack lunch versus a tray lunch, playing the state lottery, attending an ex-stepfather's funeral, and the limits of travel when on prison furlough. Is there anything in the New Mexico due process analysis that does that kind of a weight or consideration?
It would be very helpful if there were. I can't think of anything off the top of my head. That's not to say that there isn't anything. My mind does go to Department of Workforce Solutions v. Garduno, which the petitioner cited in his brief in chief. That case cites to Board of Regents, excuse me, versus Roth, in which the federal Supreme Court talked about the interests at stake and talked about how, and I apologize if I am getting the wording wrong, that there's a significant interest in continued employment. That was the issue in Roth. And in Garduño, the issue is there's an interest in receiving unemployment benefits. Those are both, I would argue, things that are important to life. They're income, they're how people exist and feed their families and whatnot. The issue here is much smaller. It is whether Bryce Franklin is allowed to purchase things like Axe deodorant, Olay soap, Lucky Charms from the vendor of his choosing when there is another vendor available for him to purchase from. So I don't know if that gets you anywhere, Justice Vargas? I'm sorry.
Are you finished?
I am.
So whether we're talking due process under the United States Constitution or New Mexico due process, either one, they both require notice and opportunity to be heard. Am I right?
They do. However, that
So let me finish my question. Was Mr. Franklin afforded either notice or due process when the Bureau of Prisons changed from 4 vendors to 1 vendor being approved without, did he get notice or opportunity to be heard that was happening?
not that I know of from the record, Your Honor. I don't believe so.
So if I'm right, and if you're right, it would appear that he was denied due process, whether you're talking state or federal.
Again, and as we likely I respectfully disagree with you that there was no property protected interest, so due process rights did not attach under federal law.
Assuming there was, he did not get notice and he did not get opportunity to be heard.
Again, that's what the record shows. However, under federal law, the Wolf case said that the actual due process requirements may be limited within, again, in the prison setting. So if we're talking about that here,
It can't be an arbitrary.
it can't be
exercise. And I
arbitrary.
think that goes to the senior justice's question of if it was just a secret that they had changed the list of vendors, it starts to go down that path of being arbitrary because there was no notice.
And I can see that concern. The other side of that coin, though, is that if the court finds that there is this protected property interest in ordering from one of these vendors, it does then create these rights. And I don't know quite what the form would take, whether it would be written notice, a hearing before anyone is told they can't order from the vendor of their choosing. That is going to create many new causes of action and many new things that may be brought to this court.
The DOC could have just changed its written policies and then the person would have had notice. Some of this could have been avoided, so.
So in there, on this sort of minimalist argument, is there a difference between saying, for correction, saying, prisoner, you may not have Lucky Charms, may not have a PlayStation, and prisoner, you may have those 2 things, but you must do it this way. In the latter, is there really a creation of property right in Lucky Charms? Or is it the creation of the right and you may do it this way? Do you see a difference between those 2? Or not, from the Department of Corrections? In either circumstance, is there a difference?
I think, Your Honor, there would be, if there is, again, hypothetically speaking, the right to acquire these things this way. That's entirely separate from the right to Lucky Charms. One of the things, and I know this is citing federal law, but it has been favorably cited by our courts and Cordova v. Lee Master, the Turner v. Safley factors, one of them that when evaluating whether or not there's a legitimate penological purpose, one of the things that can be considered is whether the inmate is provided with some sort of alternative means. Staying with the Lucky Charms example, it's not that he's told you can't have Lucky Charms, you just can't order them from Walk-in Horse. We're ordering everything through Union Supply.
And in order for the petitioner to prevail, is it your argument that we would have to address that precedent and say you have a greater due process right under the state constitution to the extent that Department of Corrections could not give them the alternative? Once the Department of Corrections has identified those, they're stuck with it.
Let me make sure I'm understanding the question correctly.
I guess I'll just get in the reverse. All you seem to suggest is Department of Corrections can create these regulations and then just, because of their discretion, I don't want to say ignore, but ignore. Is that your position? It's built into the discretion of Department of Corrections.
I believe it would have to be, Your Honor, that there's not this unfettered right to acquire whatever you want from whichever vendor you want. And the flip side of that is that corrections has the discretion to cabin that in and to say these things may be ordered, these things may not be ordered.
To that point, do we need to, do we need to, and this is a state constitutional claim. We're arguing a lot about federal due process, federal cases. If we are going to interpret this constitutional claim under both Article 2, Section 18 and Article 2, Section 4, are you asking us to analyze it as analogous or similar to a federal constitutional claim?
I think that
I don't know if that question made sense, but what I'm basically wondering is, are you basically saying what the rights that we provide under the state constitution are analogous to what's provided under the federal?
I think that is largely what we're saying. And I do want to point out that the reason that it was argued primarily under federal law in the answer brief is because coming out of the brief in chief, it appeared that the petitioner's claim was that they were analogs. However, the state constitution should provide greater direction, and the state, assuming that that was the argument, believe that was unpreserved. However, we also advanced the argument that even under state law, so if Gomez does not apply and we're looking at something that is just unique to New Mexico, this right to acquire property, and purely under the state constitution, certainly the state of New Mexico could use federal precedent as guidance, and to the extent it's been adopted by some of our other cases, it's useful there. I don't, Justice Somewhere, I probably totally went off base with that.
No, you're fine, and I'm not sure how well my question was articulated, so thank you.
In sum, the state asks that the habeas court's decision be affirmed and that the amended petition for a writ of habeas corpus be denied. Any other questions from the court I can answer with my remaining few seconds?
Thank you, counsel. There you go. 2 minutes.
Going back to the Chief Justice's question about our citing of Adobre, we cited that in our brief in chief. It's listed in the table of authorities, and we also cited it in the reply brief. And I don't mean to come across as obtuse as far as where this right derives from. The point of me talking about both the state constitution and Adobre as the basis for the creation of this particular right is because the state constitution, going back to Justice Vargas's case or question about the importance of the right, it gives it more weight if you're looking at it that way. I'm not saying that it's any less important or any less weighty for this court to decide, but I think it's worth noting, and we talk about this in our briefs, that the language used is the same. It says that the heading under which all this comes about is acquisition of personal property.
So let me ask you, getting to the question the chief asked just a few minutes ago, is Mr. Franklin actually being deprived of property here, or is he just being deprived of the right to purchase property from the vendor he chooses?
Well-
He can still buy the property.
Well, if I could just, so he's being denied the right to acquire.
Right.
I agree that that's an issue. So that's always been just an issue. But going back to what Your Honor just said about the vendor of his choosing, the vendor of his choosing was given to him by the regulation. It's not like he said, oh, I want to order from this guy. That's not it. The court, the DOC, excuse me, corrections gave him that opportunity to choose from these four vendors.
That sounds like liberty to me,
It can be liberty, Your Honor. It could be,
not property.
well, I guess I would still say,
He's given a choice of how to acquire the property,
or in our view, he's given the choice of how to acquire, right, how to acquire.
how to do it, process.
Right,
And
exactly.
that to me implicates liberty. I mean, there's no dispute that he's got a right to get canteen stuff.
Right,
That's not contraband.
right.
But what we're really talking about here is the process by which he acquires that property. Whether it's from an approved vendor, heretofore an approved vendor, or all of a sudden not.
That's right, Your Honor. And I would go back to Brooklyn, because Brooklyn kind of lays out for us what the parameters are of what the state can do in this context, right? They can have reasonable regulations, but those regulations have to be for a penological purpose, and they have to be reasonable. And in setting out the regulation the way it did, correction said, okay, we're going to let you order from these approved vendors. We've approved them, and we've looked at their catalogs, and for the most part, we've approved them. There's a presumption they're not selling you contraband, right? But we're going to impose on our property officer a restriction that, number one, he has to give a recommendation about the purchase, the proposed acquisition. And number two, he has to ensure that the proposed purpose complies with the regulations and policy of that talk about acquisition. And that's important. So that this idea that the state keeps bringing up that, oh, he just wants to order from whoever he wants to, that's not true. As Your Honor said, it was an interest handed over to him by the state.
I'm still struggling with the interest we're supposed to protect here. As Justice Vigil pointed out, it's starting to sound more like a liberty interest, and it sounds more like he's asking for a right to order from the vendor he wants to order from.
With all due respect, Your Honor, that's not what I'm saying. That he wants to order from the vendor he wants to order from. The regulation itself says you may acquire additional personal property from the following list of approved vendors. It doesn't circumscribe which one you have to choose.
I think that's what she meant by her question.
Okay.
That he's saying, I want my choice of an approved vendor.
Right, which the regulation gives him.
That's liberty. Sounds more like a liberty interest.
Well, I guess the reason I'm hesitant, I guess, let me just say this. I don't want to torpedo my argument. If you're helping me out here, I'm just saying that, you know, in the context of what it looked like with Old Gray, the liberty interest there was very clear that this is something where the person was making himself not entitled to, but eligible for a reduction in time. And here we're not really talking about a reduction in time. We're talking about property acquisition.
So if the prison were to tell him, you have to order from Union Supply, we're going to require that, but the cost was the same between Union Supply and Walkenhorst? Have they violated his rights?
Yes, because again, going back to what I said earlier about, I have to say this, that the policy as written, I believe, was an attempt to comply with the law. It's a recognition of a right to acquire property that continues in prison. It's a recognition that right can't be fully compromised. But
And
that
it makes it sound like you're saying his right is to order from a vendor
is right
On the list, right?
on the list.
on the list.
Right, his right.
It's not to acquire property, it's to choose the vendor he wants to choose.
That's right, and there's nothing wrong with that, because it's not implicating, this is where I go back to, it has to be reasonable, it has to be, penological interest. Here, that's not this, they, as the court was talking about before with opposing counsel, they didn't say this is, you can't have this because it's contraband. They said, you can't have it because this is the vendor that we have a contract with, we make money off of this, and that's who you have to choose. That's what they did, so they.
So, but if they amended the policy tomorrow and it said you can only acquire property from Union Supply, you'd be fine with that because it would be in writing?
I would have to be fine with that unless there was another issue about that. But yes, I mean, it says, it gives the person an opportunity to acquire. But what another point I wanted to make about that is that in this instance, the problem is that people also have a protected interest in the funds in their prison account, right? When the prison is saying, you need to order from this supplier here, and that supplier is charging significantly more money. Again, you have a property interest that's implicated by that because now they're being asked to forego.
That was created by another regulation, allowing them to have their accounts.
Right. So it's all part of the piece. And going back to your questions, Justice Vigil and Justice Vargas, about the right to acquire. Again, it's compromised when you're saying to an inmate, you have to order from this vendor because this is who we have a contract with. When the regulation itself, the policy by which he's following, says nothing about that.
To get to the chief's hypothetical, they didn't say you can't have Cheerios. They said you can have Cheerios, but it's got to come from this vendor. Even though we told you before, yesterday we told you you could get Cheerios from 4 vendors. Today we're telling you can only get Cheerios from 1 vendor.
Right.
They're not interfering with your right to acquire property. They're interfering with the process.
Exactly. I agree with
It's a
that.
liberty.
Yes. Liberty.
I agree with that 100% that that's what's going on here, right? And going back to the Dubray, we're in the same position of being eligible to make a purchase. That's the position we're here at, being eligible to make a purchase, right?
And if it's a liberty interest, they'll examine that under state constitution.
Absolutely. I think Dubray gives you that license.
Do you agree that Sandlin is the due process that's described by the federal court under the U.S. Constitution?
It is. I can't say it's not. I don't think it applies here, but it is. I just wanted to say one more thing. As far as contraband, again, I think that's a distraction because that's not why they said, but there is a definition in the policy itself as to what contraband, or it gives a very clear definition of what contraband is. So it's not like it's just an absolute unfettered discretion that these officers have. They are cabined in some way as to what they can deny or approve of.
So there's something that you said, and maybe you can't clarify it, but I'm confused as to why you're saying, it was to Justice Vargas's question, that if Union and Keefe were the same price, or all 4 of them were the same price for Cheerios, that you would still have a violation.
Well, in that, the process that they've given the inmate is that you can choose, and that's where I go back again to my argument. May I finish the question?
Yes.
That's where I go back to my argument about going back to Brooklyn, is that when you're talking about curtailing a constitutional right, it has to be reasonable, it has to be for the public welfare, And in this instance, it would have to be from penological interest. Just saying, you can order from this one, but not this one, even though we've approved all four, you can order it. It's just arbitrary.
All right, thank you, counsel.
Thank you.
Matter S-1-SC-40715, Franklin versus Martinez, matters taken under advisement. The court is in recess. Thank you.
Step the court, please.